I would have to say to that question, it applies mostly to newer lawyers, all right? When I had tried a case against a newer lawyer, I don't know, 10 years ago, I was offering some evidence. The lawyer properly made a foundation objection. And I went through the dance of laying the foundation for the testimony. Who else was present? Where were you at? What did she say to you? What did you say in response? Blah, blah, blah. And so I lay the foundation and I moved to offer the evidence. And the lawyer says, I object. And I said, I looked at the lawyer and I looked at the judge and I said, Judge, I laid the foundation. And the lawyer said, oh yeah, he's right. I'll withdraw the objection. Well, it was hearsay. It wasn't probably relevant. It probably wasn't that probative. So the takeaway point I want to say is all evidence needs to meet three requirements before it comes in. It needs to be a proper foundation needs to be laid for it. It needs to be relevant, which means it has to be probative of an issue and controversy. It needs to be material. And finally, it needs to comport with the substantive rules of evidence, hearsay, original writing rule, etc. So you have these three prongs, all of them need to be met. So the point I'm making here is if I can satisfy one of the three prongs, it doesn't mean it comes in. I need to satisfy all three prongs for it to come in. So I would say that probably is something that I see a lot of confusion with newer lawyers, where they don't necessarily understand that you need to achieve those three hurdles to get something in. So another point on that subject, I would talk about, I guess at the beginning, my prefatory comments. Your knowledge of the rules of evidence is only as good as the judge you're trying the case before. So you could write a book on evidence. And if your judge doesn't know the rules of evidence, it doesn't really matter. So you need to work with who your judge is and do whatever you need to do to get your case into the record, considering your judge. So again, you may be crack at evidence. If the judge isn't, it's going to be a long afternoon, that's for sure.